What's up, everybody? Happy Monday. We're here. We're ready to hang out for a while, ready to talk about some updates in this Kohberger case and the Idaho case. I saw some messages already about what's going on with Israel and prayers for Israel and the horrible attacks happening there, and retaliation that's coming and ongoing. And it's incredibly sad. And our prayers go out to them for safety, for healing, for peace. As all of you know, I'm not a political expert or savant or authority in any way, shape, or form. So I'm not going to opine or guess what it means politically, but I know there's a lot of lives at stake and affected at home and abroad because of this. So we are going to keep track of that and keep praying for them. It's a world that never ceases to amaze us when it comes to the tragedy and things that can happen. And we remember the victims of these attacks and the attack in Idaho, because regardless of what happens with Brian Kohberger, regardless of he's guilty or not guilty or what happens at the trial, there were four victims and families and loved ones and extended families and friends of those victims that were victimized because of this. And we always want to make sure they're at the forefront of how we look at these cases, and that is the justice we are looking for, and the justice system. Because to arrest or convict an innocent person is not justice for the victim, or to trample on people's rights is not justice, but a fair and just legal process that ends in the conviction of the person that committed the crime is what we look for in these cases. And it's difficult, right? Because victims have so many difficult decisions to make. They don't know how they're going to act once they get in these situations. We've talked about that so many times, that it's hard to blame anybody for what they do when they're put in positions that are impossible. And that's what the Goncalves family has been dealing with. And, we've been trying to update as things have come out. And there have been some new articles and reporting based on conversations with Steve Goncalves, Kaylee Goncalves' father, about they have hinted at and made mention of the investigations they've done on multiple outlets. They have mentioned that they've talked to coroners and law enforcement officers and had private investigators, and didn't necessarily watch, wait, or trust law enforcement or the state to do the investigation, but felt like it was necessary that they jump in. So, as an extension of that, when we have some of that information, it makes us realize and understand that there may be more that even they know that we don't know. And they may have done more of an investigation than we know currently, or maybe they haven't. And I feel like these reports are worth discussing, because there can be some legal ramifications if what they're saying are true, and it could affect the trial, and it could potentially be something that's in the motions to dismiss the grand jury indictment that's been sealed that we haven't seen some of. So I thought it was at least worth talking about, answering the questions, although these reports have not been confirmed by any court documents or law enforcement or anything like that because of the gag order or anybody involved. So I think that's important to, off the top, say that. But if you guys are interested in these kinds of topics, let me know by liking the video, subscribing to the page. If you want to kind of break this stuff down, I want to answer questions too. A lot of people had questions. What would this mean? What could it mean? Isn't this wrong? Is this illegal? For some of the things we're going to talk about in the process today. So that's what drives this content, is the subscribers and the people that watch the video. So make sure you do that and let me know what questions you have for any of the cases that we are covering, because that's really what drives these topics. So I'll answer that later. Okay. So the first thing I want to talk about is just, what are these reports? So some of the reports go further than what we've already seen, right? Private investigator, law enforcement, coroner, whatever it may be. They go so far as to say that the Goncalves family or their investigator has talked to two of the grand jurors that took place in indicting Brian Kohberger. And this is seen as some damning evidence against Brian Kohberger, that he bought a Dickies outfit from Walmart not long, quote unquote, before the crime for $49.99, and they have the receipt from Walmart. It was also reported as a theory of these grand jurors that the reason to explain away why Kohberger was able to get away without leaving a trace basically in his car or himself besides the DNA on the sheath at the scene of the crime is that he had this Dickies jumpsuit on and he took it off, put it in a bag, stuffed the bag in the trunk, plastic bag. I would be willing to bet there are experts that would say, even with all of that, it would be almost impossible to get nothing in the car. Now, maybe in combination with all of that plus cleaning materials, then maybe you get to a better chance of having no trace in the car. But regardless, if this stuff is even true, you're seeing that even the grand jurors potentially had to fill gaps and fill holes in the story. And that maybe some of the evidence is lacking to fill all these holes and legitimate questions people may have, like, okay, DNA might have been there, but no DNA in the car. Just legitimate questions people have been asking on this stream. And we are thinking that's very, very possible that law enforcement has a lot more evidence that they haven't shared with us yet. That's very possible. So with the grand jury potentially having to connect dots, it's possible, it's plausible, but also interesting because we know that Kohberger's team has questioned the results of the grand jury and wanted to push that burden of proof to beyond a reasonable doubt, not a probable cause type of standard of proof. And to me, that argument's completely wrong. In the grand jury, I think it's probable cause. I don't think it's a much lower burden than beyond a reasonable doubt. I don't think there's really any good arguments that the defense made to think otherwise. But if we know that grand jurors, if this is true, and if grand jurors are saying that they had to come up with theories to fill holes, maybe the defense thought it's possible the grand jury to get over a probable cause standard of proof, but not beyond a reasonable doubt. So if that changed, maybe there wasn't enough evidence to prove the case, even at the grand jury level, without defense attorneys, beyond a reasonable doubt. Interesting thought. Might be in the motion to dismiss. We don't know. Additionally, they said that Goncalves basically felt like someone told him something happened to where he found out or knew there was some kind of an informant. Okay. Usually a criminal informant is somebody that's like working with the government and, they either made a deal, they had some crime, or they're working off some time or whatever it may be, or they have a relationship with law enforcement and they're their informant, right? They're not a cop, but they're not just a random lay witness person that shows up and saw something, right? It's not the same thing as just a random eyewitness. So usually an informant is categorized as that. And like we saw in the standard discovery questions when they mentioned informants, is a criminal informant, right? They can call it a criminal informant. That's what normally pops into people's heads. But maybe this is just some eyewitness that we don't know about. Maybe it's another roommate. Maybe it's a friend of a roommate that was there that night. Maybe it's the DoorDash driver. Maybe it's a next door neighbor. Maybe it's somebody across the street. We have no idea. But these reports are now saying that there is an informant and that that Goncalves basically found this informant, or his investigator did, was about to talk to him. Law enforcement stepped in and basically threatened him, saying, you're not going to talk to this person. Okay. We're just going through right now kind of a summary of these reports and what may make them important or not. So they don't get to talk to the informant, but maybe we're hearing that there was an informant. Okay. Did they find that out from the grand jurors? We don't know. So one of the very interesting things about this is we knew about law enforcement, investigators, coroners. We never heard about grand jurors speaking to them before. And this would be really crazy to me. I don't think I've had a situation where I've seen this or, looked into or researched grand jurors going and talking to victims about the case. We know jurors in a normal trial have the right to keep their names private, but they also can talk to lawyers, victims, witnesses, news outlets, whatever they want. So what about grand jurors? And the only thing about grand jurors that I know mostly comes from the federal rules on grand jurors that I've looked into in federal cases in Florida. So we're going to start there, but we're also going to weave in the Idaho rules to talk about what happens in a secret grand jury. They're sworn to secrecy. They agree to keep things secret. What happens if they violate that? Are they allowed to after the indictment is rendered? And how could this, in fact, affect the indictment going forward? Could this be something in the motion to dismiss filed by the defense? So the first thing we're going to look at is just an easy way to talk to the grand jurors about what their job is. This is a handbook for the grand jurors. And you see from the table of contents, it's got everything in it to the purpose, the origin, the nature, how they're selected, what they do, questioning witnesses, deliberation, when they make their determination. But we're going to jump down to page 13 here, secrecy. Okay. And we're going to take a look at what it says here. The law imposes upon each grand juror a strict obligation of secrecy. This obligation is emphasized in the oath each grand juror takes and in the charge given to the grand jury by the judge. The tradition of secrecy continues as a vital part of the grand jury system for so many reasons. It protects the grand jurors from pressure by persons who may be subject of investigations by the grand jury or associates of such persons. It prevents the escape of those against whom an indictment is being considered. It encourages witnesses before the grand jury to give full and truthful information about the commission of a crime. It also prevents tampering with or intimidation of such witnesses before they testify at trial. Finally, it prevents the disclosure of investigations that result in no action by the grand jury and avoids any stigma the public might attach to one who is subject of a mere investigation of the grand jury. So you can understand that and why it's important for grand jurors to keep this stuff secret, especially if they don't end up bringing any action. It would be totally unfair if, and I said this in a members only stream the other day, that I like to do this and I hope nobody takes offense to it, but like Complex Lit. If Complex Lit was the subject of a grand jury investigation and we come in and they try to prove a case against her and they can't and they come back with no action, well, nobody should know that they ever even investigated her. Because that's going to create a stigma. She could lose her job. She could be, it could be detrimental to her family. She could get threats. And so if they break that secrecy, people have major problems. Essentially, the grand jury may disclose, so they can disclose certain things. Let's think about and listen to where. They may disclose matters occurring before it only to the government attorneys for use in the performance of their duties, but even the government attorneys may not be informed of what took place during the grand jury deliberations and voting. Meaning, even in this situation, they can't talk about the theories the grand jurors came up with and why they came to their guilty or not guilty verdict, but why they came to their decision to find probable cause for these crimes. The only other time matters occurring before the grand jury may be disclosed is to anyone is when disclosure is ordered by the court in the interest of justice. Disclosure of such matters may never be made to a grand juror's friends or family, including a grand juror's spouse. And that's really funny because somehow I'm looking at the chat at the same time as I'm reading this. My husband has been on a grand jury for 18 months and he can't say zip. I know absolutely nothing about what is presented to him each week. Not a thing. Well, Mrs. Kelly, Mr. Kelly is doing it right. And he's taking his oath seriously. And I love to hear that. Because as you see in the handbook for grand jurors, and again, this is the federal handbook. A lot of states track this. But it says they should never disclose this to their friends or family, including their spouse. Okay? So, let's take a look at Idahos rule. If you can't read it, don't worry, I'm going to read it. So, Idahos rule, and we're going to go down to C, which is secrecy of proceedings and disclosure. Let me make sure it's up on the screen here. So people are saying Peter's a real lawyer. Why would he use false information? I'm not saying this information is true at all. What I'm talking about in the questions I got is people asking if the grand jurors were to speak. And my guess is it's coming from these reports. Whether or not it's true doesn't matter as far as whether or not this is true, where if grand jurors speak, it could be problematic. And that's the question we're answering here. And in order to answer the question, I had to summarize the reports that may very well be false. Okay, so every member of the grand jury must keep secret whatever was said or done in the grand jury proceedings and the vote of each grand juror on a matter before them. But a grand juror may be required by the district judge to disclose matters occurring before the grand jury which may constitute grounds for dismissal of an indictment or grounds for a challenge to a juror or the array of jurors. No other person present in a grand jury proceeding may disclose to any other person what was said or done in the proceeding except by order of any court for good cause shown. So, it tracks with the federal rules and the federal handbook. What's interesting here is it does say that a grand juror may be required by the district court to disclose matters occurring before the grand jury which may constitute grounds for dismissal of an indictment or grounds for a challenge to a juror. So that means as part of this dismissal process that we know the defense is going through right now, potentially some grand jurors could speak, which leads us to, if any of these reports are true, and I've seen it in just more than one place, I'll just say, I'm sure it could have originated from the same place and a bunch of people are just talking about it from the same place. Absolutely. But I think it's an interesting legal question and a ton of you asked. So that's why we're giving kind of the focus is here on the grand jurors. So if they did talk to Mr. Goncalves or an investigator or anybody like that, if they did speak out of turn, and that is an issue as part of these sealed motions to dismiss, well, the court could, under the rules, force the grand jurors to speak if these conversations are subject to a motion to dismiss. Really, really interesting. Now, if the grand jurors did speak out of turn or when they weren't supposed to, or talk to an investigator, a lot of you asked, what would the punishment be? Should they go to prison? Should they get arrested? So usually I'll just tell you, we don't want to threaten jurors or grand jurors with going to prison for doing their civic duty, right? Especially if they accidentally or didn't understand, or maybe they didn't read the handbook, they got it. So, to me, I would never jump to the conclusion to throw them in prison for the rest of their life or for 10 years or whatever it may be. So to me, that is not public policy reason why what we want to do to grand jurors. But these rules are important and the law is important and oaths are important. And so we need to make sure that people are abiding by those. And in order to do that, there needs to be some kind of teeth. And the teeth to this comes down to contempt. And right here, paragraph 7. A knowing violation of Rule 6, and Rule 6 is the grand jury. We're back in the federal rules. A knowing violation of Rule 6 of any guidelines jointly issued by the Attorney General and the Director of National Intelligence under Rule 6 may be punished as contempt of court. So potentially, one of the potential problems or punishments could be holding the juror in contempt. And the reason that this tracks or makes sense is you can be held in contempt of court if you violate a court order. And I think as we think about it in our minds, and people that have dealt with different things and been here to see how different people have different remedies or punishments for things that they do. And we think about the person that took the picture of the juror. She had an argument as to why she did it. She didn't mean to. She was under, a lot of stress, whatever it may be. Problematic. Not going to prison for the rest of her life, but was held in contempt of court for violating that court order. So again, here, when you violate a court order, when it comes to the oath of a grand juror and the secrecy of the proceedings, then potentially you could be held in contempt of court. Doesn't mean that's going to happen. But these factors are absolutely something that could be in a sealed motion to dismiss the grand jury indictment for problems with the grand jurors. And some of the arguments could be, they knew Kohberger. They made up their mind before the grand jury even happened because of all the media attention. They heard these theories of, Dickies suits and plastic bags and trunks and whatever it may be on the internet, on YouTube, in the news. And that could be something Kohberger's team is fighting against. So, just interesting factors on how the grand jury, how their secrecy extends past their decision, which is a little bit different, than a regular jury. And I thought that was an interesting question that so many of you guys had similarly when these articles came out and these things came out, that how would that affect this process? Would that mean another question I got that I'm going to answer here. If this is true and these grand jurors spoke to Goncalves or a investigator of Goncalves's, does that mean that the grand jury indictment gets dismissed? Does that mean Kohberger gets to go home free? Absolutely not. Very, very unlikely that just having a conversation with the investigator, even if it violated the court order, even if they're held in contempt, it doesn't necessarily on its own render the grand jury indictment null and void and dismiss that indictment. They would have to prove that it prejudiced the process, that was wrong, something happened in addition to that, not something they said or did after the fact. So that is an interesting part as well. That even if this stuff is true, because a lot of people are running with this stuff on the internet, even if it is true, it does not mean that the grand jury process itself was defective. It does not mean that the case must get dismissed. It does not mean we have to impanel a new grand jury. It doesn't necessarily mean that. So I just want to make sure everybody understood that because I had a lot of that question as well. All right, let's get to some questions that you all have. What's the obsession? Oh my gosh, I can't believe I caught a live stream. Day off of work. Woohoo. Thanks for all you do, Lawyer. This is such a great channel. Thank you so much. What's the obsession? Ashley, why would the grand jury say that they had to fill gaps? So that was my interpretation of what they said. Okay. Just to be clear, the reporting, the different articles that I read and different things people said is that they said, oh, Kohberger, because there was no DNA in the car, Kohberger must have taken off this Dickies onesie, stuffed it into a plastic bag and put it in his trunk. And that's how he kept no DNA in his car. And in my mind, that's them filling a gap. They didn't say they filled gaps. So I'm glad you asked this question because if it made it seem, so there are no quotes. This could be false. That's why I love playing YouTube videos of the jurors actually talking after the trial because we can quote them and hear exactly what they say and things can't get lost in translation. So thank you, Ashley, for helping me make this disclaimer of this just hypothetical thought process we're going through. That's all this is. SB Gansky, is that the grand jury's job to make up unknown details to make the suspect fit the theory of the crime? So the grand jury's job is to determine whether or not there is probable cause enough to indict somebody for a specific crime. They don't have to have every piece of evidence. They don't have to prove the case beyond a reasonable doubt. So yes, they can make inferences based off the evidence, reasonable inferences. Kit Kat, thank you, Peter, for all you do. Hugs from Canada. And to that last question, gaps are filled and inferences are made in every case. So that's not necessarily unusual, but the lower bar is important. Probable cause standard is very different than beyond a reasonable doubt, as we've seen from very long motions filed by both sides. Meggie, are grand jurors allowed to talk to anyone outside of the court? No, they're not supposed to. They're supposed to be sworn to secrecy, basically, unless they're ordered by a court. Netwoman, I sent you a DM on Instagram regarding the Crystal Rogers case over the weekend. Brooks Huck's family were caught recording during the grand jury. So I saw some of this. I have no idea really about this case. I was flying back home this weekend, finally got to see and hang out with my kids. So I haven't looked at anything. I will try to take a look at this. Here's a good point. If everybody else is interested in this too, let me know in the comments and on DMs. Randy, I got my first jury duty notice last week. So excited. I've had multiple people reach out and say that they are excited for jury duty. They feel like they're ready. They feel like they're going to go in regardless of what they think. They're going to wait, listen to the evidence, listen to the facts, make their decision based off that. That was important as well. Correct, Alicia. They don't have to give all the evidence, just enough to indict and just enough on a probable cause standard, not beyond a reasonable doubt. All right. Ashley asked, when will you finish reviewing the YNW Melly AG hearing? So I asked for people to say in the chat if they wanted that. There wasn't a ton of it in the comment section. So I didn't want to take another, 2 hours if people didn't care about it. If people do want to see the examination of I actually thought there was less fireworks than the first half. I thought the first half of the hearing had way more fireworks than the second half. She basically said what I expected her to say. But if you guys are interested in it, I will go check out and we will review the assistant state attorney Bradley, who is the basically main subject in a lot of the issues with YNW Melly. If you want to see that second half of the hearing and her testimony, let me know. Thank you, Carrie. Could it be possible that Goncalves testified before the grand jury and not to the grand jury? If you do something before the grand jury, that usually means to the grand jury. If you mean he talked to them before they were grand jurors, that would be much worse. To me, if this investigator or Goncalves himself talked to grand jurors before they were impaneled on the grand jury, that would be much worse, but I don't think that's what happened. Pebbles, do they have to be informed if exculpatory evidence exists? I believe the answer to this is yes. There's some gray areas in this, and the other, if you're following Melly at all, the grayest of gray areas when it comes to exculpatory evidence is what is exculpatory evidence and who determines that it's exculpatory. Because as you'll see in Melly's case, the defense thinks certain things are exculpatory. The prosecutor doesn't think they're exculpatory. The prosecutor does not have to tell those things to the grand jury if they don't think it's exculpatory. But they should give a full picture of the case and provide exculpatory evidence that they believe is exculpatory. Now, usually they wouldn't bring a case they believe something's exculpatory. So again, there are some gray areas and it depends around this, but I think yes. Mama Rebel, welcome to the membership crew. And I think it's a good time. We are going to do a members only live on Friday of this week. I think around 2:00 p.m. Eastern. And we're going to do an office tour here of our Clearwater office. We'll do another one for the Dunedin office at another time. But John's going to be here. We're going to do an office tour of the Clearwater office. So if you want to join the membership crew to hang out for that, membership stuff, we just hang out, we have fun. I'm going to add some stuff to it. We're going to do more just hangouts, just relaxed, chill Q&As, but it's never like a legal breakdown thing like this. So if you guys can't become members, not a big deal at all. You're not missing any legal breakdowns or any of the legal content. It's more just hang out, get to know us more behind the scenes, meeting John, meeting my wife, seeing the office, things like that. How does the grand jury really know that the walls are paper thin at the house? How do they know DM and B weren't lying? Well, how does any jury or any person or any witness ever know that somebody's not lying? It's very difficult. So, I don't know the answer to this. Why does the defense care about the grand jury if it won't matter? It will matter. I mean, if they can get the grand jury indictment dismissed, then they'll have to re-indict him. And potentially that'll start the speedy trial clock over again. So it could absolutely make a difference in in how the case goes. And again, once you get it dismissed once and you got to bring it back, then, as prosecutor, you may get a little more nervous. Is it going to happen this time? We got to make sure everything's above board. We know they're going to fight everything. So it could still be a big deal. If you're saying it won't matter because a lot of people don't think they're going to get it dismissed, well, just because we think they're going to lose, criminal defense lawyers file things all the time that they try really hard on that end up losing. So just because you're going to lose doesn't mean you don't fight hard for it, but it absolutely could matter. Whether it will or not, I don't know. Saint Beauty, I think that her or Bury. I can't tell what that's supposed to say. The membership lives are a nice break and so much fun. Yeah, we try not to talk about all the misery that we talk about in all these cases all the time. Betty, can we hire you if needed? So, I am a real lawyer. Some people don't know that or don't believe it. And I have a law firm in Tampa, Florida. We do have reciprocity in a lot of states and multiple with lawyers barred in different states. So if you do have a case that is a wrongful death case, personal injury case, car accident, things like that, shoot us an email. We would love to be able to see if we could take your case and we could help you. So if you do have a case in the practice areas that we handle, then maybe you could hire us if needed. So yeah, save the name, number, all that stuff. LawyerYouKnow@gmail.com. TragosLaw.com is our website if you want to check that out. Angie, how do you pronounce exculpatory? Exculpatory. It's kind of like the Google thing. Exculpatory. Exculpatory. Tori, I put together for some unknown reason. Welcome, Jen. Hopefully we see you on Friday. Donna Lee, Peter, do you think Judge will announce no cameras in the courtroom now that all this has come out? I don't know that cameras or no cameras in the courtroom is going to affect this at all, right? We've had the gag order. We've had no cameras. I should say we've had sealed things, and people are still talking about the case. People are still wondering, and if anything, they're trying to fill holes and gaps. And a lot of these reports are saying, like, because of the gag order, because of the lack of sharing of information, the Goncalves family felt like they had to do something like this. So, if anything, I don't know, maybe it would make him think the other way. Holly, what receipt did Kohberger keep? Kohberger, people say Kohberger is how that's how you wrote it, but I've just been hearing people say Kohberger. So apparently and allegedly, it's a receipt to Walmart for $49.99 for some Dickies jumpsuit. Ellen, even if jurors spoke and indictment is dismissed, they can still prosecute BK through normal trial right. So no, they would have to go back and either have a preliminary hearing or do another grand jury proceeding to indict him. So yes, they can go back and do it over again. So the case isn't over, but no, they can't just say, okay, the indictment's out. We keep going towards trial. They got to restart the process over again. Joe Blow, question. Did the police look at multiple people? Can it be possible that the police gave the best match to the grand jury? The DNA, I think I heard after testifying, the FBI searched her house. I'm not sure what that last part meant, but we don't know if they looked at multiple suspects. And I think that's something the defense wants to know, which is why they want to get all this DNA evidence. They want to see who else they potentially ran through the machine to test and see if there's any other people that could possibly be connected to this. So I don't know the answer to that, but it seems plausible that there could have been somebody else in the beginning, but we just don't know that information yet. Tanya, thank you for the super sticker. Nirvana, when would witnesses possibly take the stand? Do you mean at trial? I mean, they could take the stand at any point during trial. Sorry, I'm not positive what this is in reference to. Kristen, can you do a preliminary hearing with a gag order? Yes, absolutely. Crystal, question. If they go back and redo the grand jury, would it restart the speedy trial clock? Yes. Well, it would. I'm pretty sure the answer to this is yes, even in Idaho. All right. So there was something else I wanted to say before the video ended. I think we talked about the new member benefits, more icon stuff, personalized emojis, and more hangouts and behind the scenes stuff. So if you're interested in that, make sure you're also checking out the community page on the membership stuff. We talk about it a lot there. Melissa, can your average citizen be on the grand jury? Absolutely. Brooklyn Basement. Hi, Peter. Hope you had a nice trip. Thanks for sticking with this case. Thank you, Brooklyn's Basement. It's interesting. It's so interesting. This case, I love the cases that I love the discussions around the cases that have interesting legal principles and questions. And this was a very interesting one to me, one I'd never dealt with. That if a grand juror actually speaks to one of the victim's family members. Never seen that one before. So I want to just look up and see, what even the punishment was. And it made sense and track that it would be a contempt of court because it's a violation of a court order. But it's just interesting, right? When these new questions come up and you guys all asked them. And I was like, you know what? I don't really know the answer. I know there's got to be some kind of repercussion. Really interesting. Nirvana, on this case, when can we hope to see witnesses? Day 2 of trial. They're going to pick the jury, opening statements, and maybe some motions and things day 1. I mean, I think we could have witnesses as soon as day 1 or 2 of trial. I think it's going to take a while to pick a jury, though. Kokomo. Peter, are you surprised there wasn't any DNA in the car? I'm not. I am a little surprised, if I'm being honest. I am a little surprised that they couldn't find something. Usually they can find something, especially when the scene is like it was described here. And even just a little bit of something, I think, would have been enough to really be a huge piece of evidence, because we've got cleaning material. We've got all the time in between when it happened and, no weapon. So he easily could have ditched clothes or things like that and ditched all the traces. But to really do a good enough job to clean it all out or to not have any of it touch it in the first place is really interesting, to say the least. All right. Let's see what else we got. Nicole said, almost 5,000 viewers, only 371 likes. Let's hit that like button, everybody. If you're continuing to be, maybe you guys are not as interested in this as you once were, which is totally fine. And I'm willing to pivot to cases you guys are most interested in. So always let me know by liking the video if it is something that you're still interested in, and I'll keep digging in. I'll keep trying to answer the questions that you all have for me, that you're sending me on social media and things like that. So Michelle said, how is it that anyone is talking to members of the grand jury? I served on a grand jury over 25 years ago, and they were very strict with consequences for speaking. I've never said one word to this day. I'm with you, Michelle. And that's what I'm saying. I do think it's unusual. I've never come across this. I've only been doing it 10 plus years. So I haven't been doing it I talked to my dad about it too, and he's never had to come up with him either. That's 50 years. So interesting. On this case, okay, I think I answered that one. Martha, welcome to the crew. Netwoman, can Steve Goncalves get in trouble for the interview with the gag order? Highly unlikely that any judge is going to punish a victim's father of a case like this. If anything, the judge may say something like this to Steve Goncalves. The process has to be the way it is to keep it fair. The last thing we want and the last thing you want is to have some appealable issue happen where we convict this guy. And I mean, the judge wouldn't say where we convict this guy, but where we have the outcome of the trial and then it gets appealed and there are major issues and it gets overturned and we have to do it all over again. And, something happens to where we can't go forward and there's more delays. Nobody wants that to happen. That's why the gag order. That's why maybe you shouldn't do interviews, because you could poison the jury pool. And then again, changing venue, things like that can make it all more complex and complicated for you as well as for us. So potentially some kind of discussion like that, not so much as a reprimand. And I really don't think he's going to be able to, shut him up with some kind of gag order. Theoretically he could, but I mean, I wouldn't see it happening. Belinda, thank you for the super sticker. Nirvana said, Maya trial, she took the stand today and it's heartbreaking. I can't imagine. That's an incredibly sad case. Incredibly sad case. Yeah, I see some questions in here about Maya. I've watched some of it. I have not watched all of it. Again, I don't want to keep beating a dead horse about how I'm not going to dive too deep into it, but I absolutely think there were problems. I think medical malpractice is a very difficult hurdle to clear in Florida. The doctor's bar has a lot of protections in place, and some things that seem like obviously medical malpractice, it's like, what? They're not. There are certain rules in place that a doctor could drive drunk and hit somebody in a car and they would lose their arm and the doctor would be liable for that. But if the doctor showed up drunk and cut off the wrong arm, there could be potentially no medical malpractice case, depending on the age and whether or not that person has kids. We call it the free kill bill in Florida, if you want to look it up. So medical malpractice is a very difficult thing to move forward on. I think they have a lot in this case that the jury is going to look at and really not like the medical providers potentially. But I do think also the defense is going to have some certain legal arguments that they're going to be able to make that technically and legally may hold some water. So I do think it's going to be an interesting case with a very interesting outcome, and I'm going to pay attention to the outcome. Yes, there was somebody that has already settled for a couple $1 million, but it's the hospital we're talking about. And they have just so many protections in Florida and arguments that they're going to make. All right, let's see what else we got. Yes, I did watch the second part of the YNW Melly hearing, D, with the direct of Christine Bradley. And if you guys are interested in that, let me know in the comments and I can do another video on it if that is something you're still interested in. Yes, Rob is covering Maya, if anybody's interested. All right. Why is BK dragging this out if he's not guilty? So Jackie, they were trying to push us as quickly as they could, but at the end of the day, if you whether you're guilty or innocent, if you don't feel like you're prepared and ready to go to trial and fight your case, you can't go just so that you look innocent to the people that think if you're innocent, you'd want it to go to trial quicker, right? You can't make your decisions based on that. You really can't. All right. I appreciate everybody for joining me. Again, members only coming Friday. A lot more stuff coming for the members too. If you do join, let me know if you're new. I appreciate you all jumping in and joining me. 5,000 of you this Monday afternoon. Don't forget to hit that like button and subscribe to our page if you haven't subscribed already, so you can catch all the content on all these cases that we're covering and continuing to let me know what it is you want to hear. You saw people talk about Melly and Maya. That's how we pick the content on the channel. If you're new here, is purely from you all, the watchers, the subscribers, the members, the commenters. So I appreciate you all so much. Thanks for joining me. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media, Twitter, Facebook, TikTok, at Lawyer You Know. But on Instagram, we are still at Tragos Law. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us lawyeryouknow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.